Associate Justices of the Supreme Court of North Carolina. Yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. Our first case this morning is North Carolina Bar and Tavern Association et al. Versus Cooper, and we will hear from the appellant.
May it please the court. My name is Jim Doggett, and I represent the governor in this appeal. I'd like to reserve 5 minutes of my time for rebuttal. Your honors, 4 years ago, our lives were turned upside down. A new virus without any known proven treatment and without any vaccine quickly spread across the world, threatening to overwhelm our healthcare systems. In response to that extraordinary crisis, state governments took extraordinary steps to protect public health. This court, for example, stopped holding in-person oral arguments like this one in March 2020. It didn't resume them again until November 2021, nearly a year and a half later. During the pandemic, bars operations were restricted as well until they gradually reopened. In this case, a group of those bars assert a variety of claims against the state, but principally they seek to hold the state liable in damages for its COVID response. The relief that they seek is unprecedented. We aren't aware of any case where a state court has ever held a state, or a federal court has ever held a state liable in damages for business closures. And my friend's brief, they don't cite any case like that as well. More importantly, however, plaintiffs' claims, the 3 claims they make, fail on the merits for a number of reasons and should therefore be rejected. First, their claims under the Equal Protection Clause and the Fruits of Labor Clause both fail on the merits, and also because they have not sought the least restrictive remedy. Second, their claim for statutory compensation under the Emergency Management Act fails because the state never took physical possession of their property during the pandemic to respond to the emergency, and also didn't otherwise effectuate any constitutional taking. And third, their claim for attorney's fees under the Public Records Act fails, as well because they haven't successfully compelled the production of any records in this lawsuit, which is a prerequisite to receiving award fees.
So I want to ask you about the first 2 points you made. So you kind of, in that introduction, you emphasized the idea that it's somewhat unprecedented to say you have to pay us all this money for having shut down these businesses that you meet in the state. And then you mentioned the least intrusive remedy idea again in your first point. I mean, haven't we disposed of that issue pretty much entirely now with the final holding in Ace Speedway? Because what I think the court said pretty clearly in Ace Speedway is what quorum was describing when it talked about that is the court's own restriction once the constitutional violation is proven. So in other words, your friends for these plaintiffs have no right to come in and say, we want money and we're only going to take money. They don't get to decide that. The court, if they prove a constitutional violation, will determine what the appropriate remedy is to remedy the violation. So that isn't that somewhat irrelevant now, what relief they're asking for?
I guess I have 2 responses to that. So first, I agree that this court can only reach the issue of the least intrusive remedy if it decides there's a constitutional violation. That happened below in the Court of Appeals. We strongly disagree with that decision and think it's wrong on a number of levels. But if this court were to find a constitutional violation, at that point, we think there'd be no reason not to go ahead and sort of address the Washington v. Klein factors, which show clearly there just shouldn't be an award of damages at all. Second point is, I'm also not aware of any court that's held a state liable in damages for business closures. Even that, setting aside the damages issue, would be an extraordinary finding. I mean, clearly injunctions were issued, but finding liability in this context of where damages might be the only remedy available, I'm not aware of anything like that.
Well, are there other states with fruits of your own labor provisions?
I believe there are. I think it's language that we used during Reconstruction, and there are certainly law of the land clause claims. I mean, there are also equivalent equal protection and law of the land provisions in other state constitutions as well too.
I have a question about the least intrusive remedy that I've been sort of pondering for a while with respect to this case. Isn't there an argument that actually injunctive relief would be more restrictive in a situation like this? Going back to sort of the beginning of the pandemic, as you've invited us to do, isn't it more intrusive for courts to be micromanaging the executive's response to an emergency situation than to come on the back end and, apply monetary damages to remedy whatever violation might have occurred?
I mean, I think they're both intrusive remedies. There's no question about that.
Well, all remedies are going to be
Right.
intrusive.
But I think damages are especially intrusive given the context we're working in here. This is not like a typical law versus equity situation where we're talking about the common law. We're talking about constitutional claims. And there's a strong tradition that the state has sovereign immunity against constitutional claims.
But I think if we were, here at an earlier point and we were here on injunctive relief, you'd be saying, well, that's too intrusive because that's the courts trying to micromanage the executive's response to an emergency situation in real time. Wouldn't you be saying that?
I think we would be arguing that the claims fail on the merits because of the need for the...
But if we didn't think they failed on the merits, wouldn't you be arguing in that situation that injunctive relief would be too intrusive?
Respectfully, I don't think we made that argument. I think we were careful during the pandemic never to suggest that damages would be an appropriate remedy because we saw this day possibly coming in the future and didn't want to go against the typical state sovereign immunity and just get rid of that. I mean, the damages here, we're really talking about extraordinary damages when you think about it. I mean, an enormous number of businesses were closed during the pandemic. This would be setting a precedent that would chill the state's activities, not only in the context of this emergency, but in others as well too, because they would know that there would be looming in the background possibly an enormous sum of damages that would be owed to businesses that are closed. So I think damages are uniquely intrusive in this context. I mean, really, it'd be staggering if every business.
To follow up on that point, there's also another problem with saying, well, come in on the front end in a pandemic like this and seek a preliminary injunction, which is that when you're standing there asking a judge to balance the equities and you have one side saying, my business will be shut down, it could ruin my livelihood. And then the state comes in and says, if you enter this injunction, if you don't allow us to do what we want to do here, millions of people could die. No judge is going to balance those equities and say, well, we need to put an injunction in that this business doesn't get closed. And that's why it does seem like it's much better and less intrusive for the courts to come in and craft a remedy after the violation's been proven, rather than say there's some expectation that you need to rush to court in the middle of the pandemic and try to ask courts to start enjoining the government's actions.
I would resist the premise of the question because we know during the pandemic, Superior Court, at least one Superior Court judge did enjoin the governor's orders. He did. It happened, and it happened across the country in certain cases as well too. It's not some fantasy that judges are going to be receptive to arguments about injunctive relief. Damages would be enormously chilling because the state wouldn't be simply acting on the context of like, well, could my order possibly be enjoined? But 3 or 4 years down the road, could we be talking about billions of dollars in damages? That's
You're
the thing.
talking about damages that, ultimately would be spread out among the taxpayers, but you're completely missing the idea that there's a constitutional right for the enjoyment of the fruits of your labor. So each individual business owner has a constitutional right to preventing the government from unduly preventing them from having the enjoyment of the fruits of their labor. How can you not at least give some credence to this fundamental right?
Well, I'm not giving it no credence. I mean, I think if a violation were established at that point, you go on to look whether or not damages would be appropriate under quorum and under Washington v. Klein. But I'm happy to discuss the merits as well of these claims. So they assert claims under the Equal Protection Clause and the Fruits of Labor Clause. And in this court's recent decision in Ace Speedway, it reaffirmed that the traditional rational basis test that this court applied in Poor Richards and has applied for decades is the governing standard here. And under that standard, we ask 2 questions. First, we ask whether or not the government acted for a proper purpose and whether or not its means used to effectuate that purpose were reasonable.
So let me push back on that. And there's a little bit of deja vu because we went through this with the state and Ace Speedway also, but now we have the test that's been articulated from Ace Speedway. I don't think that test could possibly be described as rational basis. But let me just ask you 2 points. The first is, it's my understanding that in rational basis review, it does not matter what the government's actual purpose is. The only thing that matters is there a purpose, a conceivable, legitimate government purpose? Would you agree with that?
Under certain formulations of the doctrine, I think that's right. I think the Supreme Court has discretion to apply the rational basis standard in a different way than is applied elsewhere. I would agree.
Well, to be fair, then the problem is if you're saying that we have a rational basis standard that's different from what federal doctrine and all the law professors that teach this in con law think rational basis means, we probably should stop calling it rational basis.
Well, I would.
Because it's really, you're just going to start getting confused. Then you're going to have a different doctrine kind of seeping in. But so it sounds you agree with me that one key difference is we are going to ask what is the actual government purpose, and the plaintiffs in these cases can prove that the state isn't being honest about what the purpose is. There's some other purpose that may be improper. And then even if you show that there's a proper governmental purpose, we articulate in Ace Speedway very clearly that the next step is this fact-intensive question of degree where you examine what are sort of all the alternatives that the state could have chosen, and understanding that there are all these alternatives and that have different burdens and benefits. Is the one the state picked reasonable in light of all those other options? And in, again, traditional rational basis review, you do not do that. You ask in isolation, was it rational to do this? And even if every other option is so much better, that you'd say this is a really dumb choice the government made, it would survive rational basis. But it would not survive the test we articulated in a Speedway. So don't we maybe just need to think of this as the fruits of their labor test now and not the rational basis test?
I have 2 responses. First about nomenclature, and second about how I think the test works. So first, with respect to nomenclature, I'm not calling it rational basis review. I mean, I'm citing Balance, Roller v. Allen, Poor Richards, we could, Duggins. This court has said over and over again that the question is whether or not the state's actions are rational. So that's not me saying it. That's this court saying it.
Well, what didn't Balance say? Real, rational, or substantial basis?
Or substantial.
Right,
Real,
so
or meaning real, rational, or substantial. It's not like that's some magical formula that only applies when fruits of labor claims are at issue or something like that. That standard, that phrasing is used throughout this court's case law when something approaching rational basis.
Right, and that created enormous confusion. So we decided a Speedway, and if you pull up that opinion and Control F search it, you will not find the word rational. We've articulated a test that can be applied that does not depend on rationality because it's such a confusing concept that's loaded with all these ideas from federal doctrine. So shouldn't we just say we're applying the test that we just articulated a few months ago in a Speedway for our unique constitutional provision, and then walk through that test and see in this case if the plaintiff is satisfied or not? I mean, that seems to me to be the cleanest way to handle the review of the Court of Appeals decision.
Right. I would just say I don't read the decision that way, but I didn't write it. And I defer to the court certainly on those issues. That said, I would say practicality. I do think the test in ACE necessarily, to be consistent with prior precedent, has to be viewed within not a blank check framework, but a reasonably deferential framework. I mean, let's just talk about some examples. So the Duggins case, for example, pretty clear that's a case about the right to earn a living. There, the court said, laws will be upheld under that standard, even if they result in some inequalities. And let's talk about the Meads case. That's a case where also pretty clearly implicates the right to earn a living, where someone's license to act as a pilot was stripped away for a year. And there, the court says reasonableness doesn't turn on narrow tailoring. It says a law can be reasonable even if it isn't narrowly tailored. And let's talk about the ASP case that we cite. There you see the court frames the test exactly the same way that this court did in ACE, and it says that laws will be upheld so long as they're fairly debatable. And again, I think I think this analysis has to happen in a relatively deferential framework, but at the same time, I'd like to point that has good policy implications too, because there's a whole range of territory that the state regulates where it needs flexibility, the same way it needed flexibility during the pandemic, to try to achieve multiple goals at the same time, to try not to have a wooden, draconian response to an issue or no response at all. And let me provide an example of that. So this state, for example, in recent years has been liberalizing its gambling rules. We've typically had a very restrictive approach to that area of the law. But with the state lottery, we moved into a new territory where the state started offering the lottery in a controlled circumstance. More recently, we've legalized sports betting. But there's still certain areas of gambling that are illegal. You can't open a casino in North Carolina just anywhere. You can't plop, a video poker device anywhere. And it could be argued that, the laws that restrict people who want to open up a casino or operate a video poker machine are very burdensome. That's a complete ban on them engaging in this economic activity that they could use to make a living, the same way people make a living in say, Nevada. And one could question, is the state's response very effective? I mean, the state tries to protect people from losing their fortunes through gambling. That's the goal of it. But would that response be effective if we're also letting people engage in sports betting? So there are whole massive territory where the political branches, the legislature and the executive, need flexibility to legislate one step at a time and to use their best wisdom about how to proceed.
I'd like to ask you about the dimmer switch approach.
Right.
I do see how you can say rationally that reopening everything at the same time creates too grave a risk to public health. So that makes sense to me. But wouldn't you agree that when you decide what businesses can reopen, it can't be arbitrary?
Yes, I agree.
You can't put them all on a spinning wheel and spin the wheel and decide
Absolutely.
on that basis, for example. One thing I struggle with here is what's the difference between a bar in a restaurant and a private bar? Because it seems to me everything you say in your filings about the risks posed by private bars, you could say about at least some of the bars and restaurants that I've seen.
Right. I would have a number. I'd have two responses principally. I think just thinking from first principles, we can see that typically speaking, that a place where people go to eat and where they may have some alcohol is just different than a place where they go to drink. The second thing I'd point is that we point to studies.
Well, actually, what I'm getting at is the bar area in restaurants with bars seems a lot like private bars. What's different about the bar area in a restaurant than a private bar?
I think it's just the principal purpose that someone goes there in the first place. And there may be some exceptions around the margins where you have behavior that looks maybe a little bit more like a private bar, but we're talking in generalities here, which is the kind of thing the state has to legislate on in a situation like this. But in the record, we also cite to studies, scientific studies, that say that there was reason to believe that bars were riskier than restaurants. I mean, one study we cite, for example, says that closing bars was one of the 3 most effective things that states could do to combat the spread of COVID-19 during the pandemic. And we read that, it actually says, even compared to restaurants. And there's another study we cite.
Well, let me push back a little bit and go to the point that the Chief Justice made, which is, I mean, we are talking about here a core state constitutional right that is being completely denied by refusing to allow people to operate at all. Why shouldn't we look at it and say, if it seems like some of the other businesses that have been allowed to reopen, and you can control the risks through restrictions similar to those that have been imposed on other businesses, that it's not reasonable to deprive, in this case, the bar owners of their state constitutional right to the enjoyment of the fruits of their labor.
Well, I guess I'd have a couple of responses. First, that we seem to be kind of thinking from first principles here when we know that people looked at this, policy experts, health experts looked at this during the pandemic and said actually restaurants appear to be riskier than bars, despite what we see. And part of the reason for that, I suspect, is that we're talking about generalities here. So not every restaurant has a bar attached to it, and not every, there's just, in situations like this, what the state is doing is limiting the aggregate risk that is happening with COVID. And one of the ways they can do that is keeping bars closed while restaurants that serve alcohol
Yes,
open as
I
well.
think that's exactly, you've just articulated for me, I think, what's so important about this case. And I should add, because I know you're sort of resisting where we're trying to go in terms of the Ace Speedway test. So I will say, I mean, I think you've made an excellent point that this is not a case where any court could enter summary judgment in favor of the plaintiffs, I mean, based on what we said in Ace Speedway. So maybe that will help you in our questioning understand what we're trying to get at. Because I do think you're asking for more than that. You're not just saying don't allow judgment to be entered in favor of the plaintiffs. You're saying enter judgment in favor of the state. And so what you just described, I just want to read you the Ace Speedway test. So it says, after you've determined there's a proper governmental purpose, the inquiry then reaches the second stage. Are the means chosen to affect that purpose reasonable? And then we say this is a fact-intensive analysis. It requires assessing two fact-specific questions. First, how effective is the state action at achieving the desired public purpose? And second, how burdensome that state action is to the targeted businesses. The analysis then becomes a question of degree. Given all the options available to the state to advance that governmental purpose, was it reasonable for the state to choose this approach with its corresponding benefits and burdens? So I agree with everything you said, but you see how, to Justice Allen's point, the state had other options. So for example, you could say, instead of shutting down the bars and allowing the restaurants that have a bar inside them to stay open, we could target the portion of all these businesses where people are packed together in front of a bar that serves alcohol, let's say. Or another example is, in the state's affidavits, it points out that the wineries and distilleries and breweries typically have a large sort of venue space. And so it's easier for the people consuming their product there to kind of spread out. But there are surely some bars and nightclubs and things with very large spaces. There are also, I'm sure, some very small spaces. And the state, again, could have had an option that targeted the size of the space where the people are congregating to drink alcohol and making restrictions on how close people can be, where they need to go in order to order the beverages, and all those sorts of things. So there are just countless alternatives that were available to the state. And as I read Ace Speedway, what it's saying is that you have to look at all those alternatives and then make a fact-intensive inquiry about, was the one the government chose reasonable in light of all the other alternatives? And it seems to me here that a fact finder needs to figure out what are the disputed facts about what those options were before we can assess whether there's a constitutional violation. Do you agree? Do you disagree with that?
Well, I've a number of responses. First, I agree that summary judgment can't be entered in front for my friends here. I entirely agree about that. That said, I would say that the notion that these claims all have to go to into discovery and trial, apparently summary judgment isn't even appropriate, that would be really something. I mean, this court in the King case, for example, resolved a fruits of labor, a claim that was similar to that on a motion to dismiss. Same thing is true about the Court of Appeals 20 years ago in the Affordable Care Act. I'm sorry, in the Affordable Care case. And so that's been the law in the state. We haven't had every one of these claims have to be litigated to trial before a jury. And that would really be an extraordinary thing, because an enormous amount of what the state does in terms of law and regulation touches in one way or another on the right to earn a living. You might say that's the main thing that the General Assembly regulates, the economy. And so we teach people in law school that first there's bicameralism and presentment when a law is enacted. If we were to adopt that approach, where every case has to go to trial, we would really have a three-step process, where it'd be bicameralism, presentment, and then litigation. And the litigation stage would probably last much longer than the others. So I would just...
Or that presupposes something that I think that our case law in Ace Speedway may achieve, which is we the people created this very unique protection of economic liberty in North Carolina. And the idea is, as you're describing, because we haven't articulated it as clearly, I think, as we have until just recently, what this right means. But now the government understands, the state knows that just like everybody else, it needs to act reasonably. So it can't just assume, as long as I'm not wholly arbitrary in what I'm doing, I'm immune from any challenge that I'm violating this fundamental right, that bureaucrats and regulators at the state will now know, I need to think carefully about the different options and try to choose one where there's a good fit between the purpose that we're trying to achieve and the way we try to achieve it. And that if people can look at what we did and say, that's not reasonable, given all these other options you could have chosen instead. We will violate the Constitution. We're going to be held to account. And I think the result of that will be better government regulation, better lawmaking, better everything coming from our government because they'll act reasonably. I mean, so I don't see really a structural problem at all. I think this could be a wonderful thing for the people of our state. You disagree?
I would just respond, it's very easy to second guess. And for someone who's not delved in policy minutia the way that policymakers are, to make mistakes. And for cases would naturally go on and go to trial where, it's pretty clear that the law should be upheld. And also, I think that reading of ACE is simply inconsistent with this court's precedent. I mean, reasonableness, in those terms, reasonableness has been used to say it's okay if there's some inequalities in practice because we're dealing with the economy here. We're dealing with areas where the states needs discretion. And same for needs. You don't need narrow tailoring. I think this court's decision in ACE has to be read within a deferential framework.
And before I realize you're getting toward the end of your time, but I want to go back to Justice Allen's point. Help me understand the difference in a bar or a bar that's part of a restaurant. At least when I've gone out, many of these bars in restaurants were separate. They could have been shut down as well if the concern is how people behave and they've lost their inhibitions or whatever. In a big bar, why is it different in a restaurant bar? If you can articulate that, because I did not hear the answer to that question to the point that satisfied me.
I think it's just that broadly speaking, when people go to a restaurant, they go there to eat. And broadly speaking, when people go to a bar, they go there to drink and socialize and be there. So it's just, you're talking about things that there may be similarities where it may be a spectrum where, some bars and restaurants may look closer to bars and bars. But the state has to be able to draw a clear line when it's regulating this. And again, this is actually not really a hard question because we know that, for example, there's a study involving the University of Wisconsin that we cited that's in the record here where using regression analysis, these people went through and said, they saw spikes in infections when people went to bars. They did not see the same thing in restaurants. So that would be an extraordinary thing for this court to say, even when we have scientific studies that suggest the state's policies are effective at limiting the risk of COVID-19, that actually courts are going to come in and second guess what they did. And this is precisely.
That's not what we're doing. What we're saying is we won't just let the state come in and hand one study and say, we don't need to listen to anything that these plaintiffs are saying. Just take our word for it and say it's constitutional. What will happen is there could be other studies. We don't know that. There could be other evidence that the plaintiffs can present that says, well, here's why that study doesn't really mean what it says, or who knows. But the idea is just that you, the state, just like the plaintiffs, will have to present their evidence, and a fact finder will decide this fact-intensive question, looking at it all and determining, was this reasonable or not? And so I'm not in any way suggesting the state didn't have reasons for doing this. I'm just saying the standard says we'll have to look at the plaintiff's evidence as well.
Right. My position would just be that that's inconsistent with how this court has handled these cases going back a century, and would be an extraordinary departure where policymaking authority would be shifting to the courts away from the legislature and the executive branch. And if this court wants to go down that road, that's entirely fine. And we totally agree. Summary judgment should not be affirmed that was granted for my friends here. If that's the rule that the court wants, then let this case go forward in that respect. But I would submit that that's just an extraordinary, drastic departure from the way these things have been handled in North Carolina before. And I don't read the decision in ACE, which is a fairly short, narrow decision. I don't think people hide elephants in mouse holes. And I don't think ACE changed the law in this state so dramatically as is being suggested here today. And I just reserve the rest of my time for rebuttal. Thanks.
Counsel? You're from the appellee.
May it please the court, I'm Bob Orr, along with my co-counsel, Matt Vaughn and Mike Toddy. I will address the issues brought forward by the defendant on the petition for discretionary review, and Mr. Vaughn will address the issues that we brought forward on ours. Let me say right from the beginning, I do think ACE controls this case across the board. And I do also want to make one factual point of clarity it would appear that the concept of bars is lumped into one big entity. But in fact, we are talking about 8 separate business entities, each of which has authority under the laws of this state to serve alcohol on premises to customers. And prior to Executive Order 141, which is at issue in this case, all of these entities had been closed down and unable to serve alcohol on premises. Executive Order 141 was enacted on May 20th of 2020, and now 7 of those 8 business entities, restaurants, breweries, wineries, country clubs, all of whom had the capacity and the permission of the state to serve alcohol on premises to individuals, could do business under certain limitations. Everyone except our clients who were constituted private bars. And all of the talk about studies and bars is a gross generalization of locations where people go and drink alcohol in an on-premise context. And it's no different. I think whether you had a bar right here where none of the customers, none of the patrons could go pursuant to 141, could go right next door to the restaurant or right down the street to the country club, have dinner if they wanted to, order a shrimp cocktail or chips, and then start drinking until the facility was closed. And so
would you agree that the courts are not equipped to manage disaster response or emergency response?
Well, I would say, Justice Allen, that the courts are here to protect the rights of the citizens. Right. And that's what this case, or these 2 issues that are here before you now, are about, as the court has noted. This is about fundamental rights set forth in Article 1 of our state constitution, protecting the rights of our citizens to earn a living without having government shut them down arbitrarily. And it also protects their rights under the Equal Protection Clause in our state constitution so that they are not unfairly and unequally penalized by virtue of this act of government. Well, and I would note, this isn't a legislative act per se. It's not an administrative rule. This is an executive order interpreting, albeit under, very serious circumstances.
It was an executive order passed pursuant to legislative authority.
Yes, it was, Your Honor.
And as long as we're talking about rights, isn't the police power here through the statutory authorization and then the governor's use of that authorization to act in a pandemic was being exercised in order to protect lives? 29,000 citizens in North Carolina died during the pandemic, and isn't what the executive was faced with was balancing their obligation and their constitutional and statutory mandate to exercise the police power to protect people's lives? Isn't that also in the balance here?
Well, Your Honor, I would say we've never questioned that the governor didn't have authority to try and act pursuant to the authority granted him under the Emergency Management Act to control or regulate the spread of COVID. What we are seeing is under this dimmer switch approach, that where some businesses get to open and some businesses are shuttered, and again, they talk about regulation. Frankly, I just don't see that as a regulation.
I'm a little worried about this conversation not tracking how science actually works. I mean, if the governor sitting in his office in March of 22 looks at the statutes defining all the places that serve alcohol, definitions concerning establishment, and says, I need to commission a peer-reviewed study to figure out which one of these is most likely to spread COVID so that I know where to draw the line. I mean, hundreds of thousands of people more would have died, right? I mean, lines have to be drawn, and scientific evidence is imperfect, particularly in an emergency. What's your response to how is someone supposed to draw lines in an emergency where scientific data doesn't graft on perfectly to legal definitions?
Well, I would fall back on the test that Justice Dietz articulated in Kinsley, and that is the means of implementing this government action affecting the rights of its citizens reasonable based upon the evidence presented? And we obviously will need to talk about the summary judgment decision that the Court of Appeals rendered, but at the hearing below, at the trial level, the state had every opportunity to present scientific evidence that distinguished our clients from the other 7 business entities that were serving alcohol or were going to be allowed to serve alcohol on premises. And there was no evidence, as the Court of Appeals unanimously found, that it was arbitrary and capricious and therefore unreasonable.
Right, but I guess what I'm getting at is I can't imagine a situation in which there would be a scientific study available in March or April of 2020 as this new pandemic is raging that draws that specific line. So it is then the answer, it's in your perspective, all or nothing. Either the governor has to reopen everything, folks will die, we're going to be okay with that because economic liberties are more valuable than physical lives, or we're going to let the economy of this state suffer, the people suffer economically by keeping everything shut down.
Well, the governor had arguably the authority to take all of the entities that served alcohol on premises to customers and say, we think it's in the best interest of the state to keep all of these entities closed. That's not what happened. And there's no evidence in the record, no evidence presented by the governor in this case that says, oh, it's okay for you to go over here to the Carolina Country Club or the Raleigh Country Club and have dinner and a bottle of wine and then go to the bar and drink with your friends and watch the ball game until 11 o'clock at night. But Joe's Bar over here down the street is shuttered and all of its employees out of work because of some balancing on the part of the governor without evidence showing that the risk over here is at least somewhat equivalent to the supposed risk over here. So
that seemed to be the Court of Appeals reasoning. I don't know if that's consistent with what we said in a Speedway. I don't think the state needs to have evidence. It doesn't need to have gone and done some academic research and found studies. I mean, it can operate sort of on instinct about what policymakers think is the right decision to make. All we were saying in a Speedway is if there's a range of possible options, and among those options, some will achieve the same government purpose or come close to achieving that same governmental purpose, but avoid much of the harm or all of the harm of the alternative they chose, that will be unconstitutional because that's not reasonable to choose the very constitutionally invasive option when you could have chosen any of these other options that avoid much of the harm and achieve much of the same result. I mean, isn't that? And so, but what I understand your argument to be is that that's the point you're going to make to the trial court, is that based on the evidence that they've presented, there are all these other alternatives that could have been done involving social distancing, allowing some larger bar spaces to remain open, smaller, those sorts of things, and that's what you want to present to the trial court. Am I right about that?
That is correct, Your Honor, but I would say procedurally in this case, the plaintiffs move for partial summary judgment. Therefore, it's what evidence the parties want to put into the record. The governor had every opportunity in advance of Judge Gale hearing this to put in all the affidavits, all the scientific studies they wanted. What they put in and what was reviewed on appeal at the Court of Appeals, the unanimous panel at the Court of Appeals said there's no evidence to distinguish between the plaintiffs in these other groups that are allowed to serve alcohol on premises. That wasn't our burden to present evidence. That was the governor's burden. And if they fail to do so, then the reviewing court can only look at the record. And so I guess my response, I hope, is what you were looking for, that procedurally the record is the record coming up on appeal.
But in fairness to the state and to I think the trial court, both lower courts, really, is that no one had the benefit of a Speedway when everything in this case happened until we get to sort of your brief and the reply brief to this court. So can't we say it needs to go back to the trial court, and the state needs the opportunity, knowing exactly what the test is now. If they want to put that evidence in, they can. Your clients can introduce whatever evidence they think needs to be in the record, and then a trial court can apply the test in a Speedway, and we'll see where we go from there.
Your Honor, I'm not sure how to answer that. I operate on the premise that, we're here now. Our clients have, suffered the damages of having their businesses shuttered for well over a year, and now we have to go back to the trial court for a process that the opportunity was there, 2 years ago? I've lost track now. But I would simply say that my understanding of the appellate process is, was summary judgment appropriate? Did the Court of Appeals get it right by saying we're looking at the evidence and there is absolutely no evidence that supports the distinction, and therefore, even though they did not have the benefit of the Kinsley test, I think whatever standard you might use, they said, well, it's arbitrary because there's no evidence here to make this distinction.
So I want to ask you,
Sure.
As you continue to talk about, and I'm a little confused because it seems like you're essentially making the equal protection argument when you say there's no justification for treating these bars different from the other 7 categories. But for the equal protection argument, bars were not the only entity that were completely prohibited from reopening under this executive order, right? So there were also gyms, bowling alleys, bingo parlors, movie theaters, gaming facilities, museums, amusement parks, a wide range of businesses that, like bars, were not allowed to reopen. And isn't the real question what distinguishes all of those facilities, including the bars that you represent, what distinguishes them from the entities that were allowed to be reopened? Why isn't that the equal protection analysis we should be looking at?
Well, because our claim for a violation of equal protection doesn't deal with racetracks, other facilities.
Right, but in assessing whether the government had a basis for making that distinction, it seems to me what the executive order seems to contemplate is that all of these places that they didn't allow to reopen were places where people were likely to be in close quarters, where they were not masked, where they were engaging in activities that would cause them to breathe a lot and spread the disease, and that the real thing that the government was most worried about was that hospitals would become overwhelmed, so that even people who said, I'm going to protect myself, I'm not going to a gym or any recreation facility, if they ended up in a hospital that was overrun because so many other people were infected, then their ability to get health care and heal and survive would be impacted. So why isn't for equal protection, to decide whether the government in some way irrationally or unfairly discriminated against your clients, why isn't the appropriate comparator the businesses that were shut down versus the businesses that were allowed to reopen?
Well, Justice Earle, I think in bringing a lawsuit, you try to narrow your claims as reasonably as possible. And in this case, we are talking apples and apples, not, apples and bananas and all these other different types of businesses that have nothing to do with alcohol. This is strictly a segment of the order that has a commonality of the other 7 business entities. While our clients are shuttered, they're serving alcohol on premises to retail customers. And I would
Let me
just
take
want
you to a higher level on equal protection. I mean, you'd agree that that gets rational basis, right? The Court of Appeals had to be wrong in its reasoning that that's a strict scrutiny claim. Do you agree with that?
Well, I will quote from Ryan v. Kmart, which is cited in the briefs 358 NC 160 at page 180. And it says, when a party challenges a particular statute is violative of the Equal Protection Clause of the North Carolina Constitution, we generally evaluate that legislation using one of 2 levels of review. If the statute at issue affects the exercise of a fundamental right or classifies a person based upon a suspect characteristic, we apply strict scrutiny. That's this court saying, citing to others.
That can't be what the court meant there. Just think about this for a second. If the fundamental right that you're talking about had a lower standard of review than strict scrutiny, but the Equal Protection Clause claim that's then implicated by that gets strict scrutiny, then you're just transitioning from whatever. So you would turn the test in a speedway into strict scrutiny, which it certainly is not. So that just can't be what we meant there. And I think it's not. This is ordinary line drawing. So this is rational basis, your equal protection claim. And this is certainly rational under that test.
I'm just citing the Ryan court, which cites several other cases in there that where you have a fundamental right, and the right to earn a living, as this court has said on numerous occasions, is a fundamental right. And our client's right was shut down, eliminated for well over a year. And I would note, and this is, we do have the statutory argument. I'm happy to argue or answer questions as long as the court might have them, but Mr. Vaughn's prepared to argue the statute. But I would note on your point, Justice Dietz, about the test for the fruits of your labor. If it really is a fundamental right, and if the state constitution is there to protect citizens from having those fundamental rights trampled on by government in whatever form that might be, a rational or even a reasonable basis seems a really low test to protect that fundamental right. Now, I understand what Kinsley says, but I raise that in the context of the Ryan decision on equal protection, that if you're talking about violating one of those fundamental rights, then the government has a stronger burden and should have a stronger burden on why it's going to encroach, and in this case, virtually eliminate that.
Counsel, before you allow your co-counsel to speak, I'll just ask you the simple question that I ask others, your friend on the other side, and I think you've made the point, but I would just like to have it said out loud. How can I reconcile when you've got a bar and then you have a restaurant that has a bar that's basically a freestanding bar? You walk in, it's a separate situation. You could either sit at the bar or you could be seated to eat your dinner, and you can certainly eat dinner at the bar. How do I reconcile that the government looked at those in a different way?
I don't believe you can, Justice Behringer. I think the circumstances in all of these entities lend themselves to the exact or similar atmosphere that potentially could occur in the private bars that were closed down by Executive Order 141.
I have, sorry.
Before you sit down, counsel,
Sure.
Is there anything that exempted the executive from constitutional compliance during this period of time?
Not that I'm aware of, Your Honor.
So I have a concern that we don't unduly fetter the executive when some future emergency occurs. So in thinking about your position, it seems to me, and so tell me if I'm wrong, you're not saying that the government can't do much of what it did. What you're saying is, if you're going to impose restrictions, you have to treat like businesses in like manner.
I would say unless there is some sort of compelling reason not to, then yes, the rights of our clients are just as valuable as the rights of restaurant owners or breweries or wineries or country club members, and therefore without something in the record that would show otherwise, then they should be treated the same, Your Honor. And we think the Court of Appeals got it right on these issues. And
Counsel, I'm sorry, I do have one more question, but just to clarify, but are you suggesting that our state equal protection clause is something different than what's in the equal protection clause in the 14th Amendment?
well, Your Honor, we have the court has the ability to interpret our provision in the state constitution.
We do. We've never done that before, right?
Correct.
For this provision.
Correct.
So
And
that would be something totally new, that if we were to say it means something other than the government will engage in line drawing and economic legislation, and that's always received rational basis in our case law and in the federal doctrine.
I will, again, just rely on what the court said 20 years ago, actually, in Ryan. All right. Thank you.
May it please the court, I'm Matt Vaughn, and I would like to address the claims that are raised in our petition for review. And those are an Emergency Management Act claim, an alternative claim for constitutional taking, and I'll probably spend less time on this last one, the Public Records Act claim, which is because the records were produced after the lawsuit was filed, has collapsed down to a question on the attorney's fees under that act. On the Emergency Management Act claim, our statute requires compensation be paid where property is commandeered, seized, taken, condemned, or otherwise used. So 5 different criteria, any one of which can meet the criteria for compensation under the Act. Now, the Court of Appeals interpreted those 5 in a way that sort of collapsed them down to one issue, which was the take issue. Or really used take and otherwise used, but really didn't make much of a distinction between those two. But then even further limited that below what would be a constitutional taking, and said this is even less expansive than a constitutional taking. And I find that analysis flawed for a couple of different reasons. One of those, of course, there's a lot of case law, both here and in the federal system and pretty much in every state, that defines what a taking is under the Constitution. And I find it illogical that the legislature, which of course would have been well aware of that, how that word is used and interpreted by the courts, that the legislature would have intended it to mean something less than the scope of a constitutional taking, without anything in the statute to suggest directly otherwise. Second, there are 5 criteria, not just take. So unless we're going to essentially say those other 4 really don't matter, that it comes down to just take, we're going to be interpreting the statute in a way that reads out words, makes them mere surplusage. And of course, that's not something the courts usually do with statutes. They usually try to give meaning to each of the words and assume they were included there for a reason. Essentially, the governor's argument would reduce the compensation provision, and in fact, the way the Court of Appeals interpreted it as well, would reduce this compensation provision to a provision that merely prescribes a new procedure for getting compensation for a taking in the wake of something done under the Emergency Management Act. There's already a well-established condemnation proceeding for when the state actually formally acknowledges that they've committed a taking and pays the money in and initiates the process. And there's also a well-developed body of case law on what a person whose property has been taken needs to do if the government doesn't initiate that process and pay money in. And so all this does, the way the Court of Appeals is interpreted, is to take these situations where they occur under the Emergency Management Act and create a new procedure, which is largely the same procedure. There's just a small difference in, I think the governor pays in some amount, and if the party wants to contest that amount, instead of getting it all like they would in a condemnation action, they get 75% and then can contest whether they were entitled to more. One of the big differences here too with our Emergency Management Act is that the question of police power kind of goes out the window. Certainly that's an important concern in the constitutional claims, because there's plenty of case law that says the government doesn't owe compensation for a taking, for example, where there's a valid exercise of police power. There is no exception for police power actions in the Emergency Management Act. It doesn't say the governor has to compensate for these things unless what he did was the exercise of a police power. By contrast, other states don't always do that. New Jersey is a good example. JWC Fitness is cited in the governor's brief, and I think their responsive brief. In that case, of course, dealt with the New Jersey statute, whatever they call their Emergency Management Act there, and it too has a compensation provision. And that provision has a specific exception to it that says the government does not owe compensation for the exercise of police powers. So regardless of whether or not what they've done might otherwise qualify under their compensation provision, the statute specifically says, but not for police power exercise. Our statute contains no such clause. And so I would urge the court not to read one into it. Our takings claim is an alternative claim, and of course a taking is only a constitutional deprivation if the government doesn't pay compensation for it. And so if there is compensation available under the Emergency Management Act, logically there's no taking, because compensation will be paid under that act. And so our resolution that we would urge the court to adopt on that is to remand for consideration of what order needs to be entered to get the governor to invoke the process and start the compensation procedure under the Emergency Management Act. But for the constitutional taking issue, the police power issue does come up. And so I'd like to address that some. If the court finds this does not come within, either consistent with the Court of Appeals or under some other reasoning, that this does not come within the compensation provision of the Emergency Management Act, then the takings claim needs to be considered. And we believe the governor's police power argument fails for several reasons. First, as recognized by this court in Kirby, the police power does allow the government to regulate under that clause or under that exception. But this is a prohibition. It's not a regulation. Regulation is what the governor did to the establishments that were allowed to open. They had to reduce capacity by a certain percent, comply with certain distancing, have hand sanitizers, things like that. But this is a prohibition, not a regulation. You can't open at all. Second, police power, it can only be exercised for purposes of public health, morals, order, or safety, or general welfare. And of course, the court recited that in the Kinsley case most recently. The governor perhaps started out on good footing when he ordered all of these establishments closed, but then he came along later, about 2 months after the initial order, and said, you know, we're going to make a distinction now, and that's where the governor misstepped. Because the basis for the distinction, the only one the governor has argued at any point in this case, is economic. The only affidavit they've supported, the only evidence they put to make a distinction of any sort between the bars that had to stay closed and the ones that were allowed to open is economic. The ones that were allowed to open create more economic benefit for the state. That is not a police power decision. In contrast, the plaintiffs put in voluminous evidence that established, without any contradiction from anything from the defendants, that they could have just as easily complied with the restrictions on opening that the bars that were allowed to open were complying with. They could have imposed those restrictions in their business as well and complied and created just the same degree of safety that you would see in the bars that were located in restaurants, in breweries, and country clubs, and other places. Another argument the governor has made, and I'll be very quick because my time's almost up, is that the plaintiff should have put their property to some other use. This wasn't a 14-month closure order. This was 20 consecutive orders that added up to 14 months, none of them more than 30 days.
Thank you, counsel. I believe your time's expired.
Okay. Thank you.
Thank you. I'm happy to answer any questions the court may have additional that you didn't get to during the first part of my argument. But there are just two issues I'd like to deal with briefly in rebuttal, just to clear things up. With respect to the takings claim, I'd like to refer this court's attention to the Stand for Something case from Texas that we cite, where in that case there's a string cite of nearly 24 cases explaining how courts across the country have rejected claims like these. So I just want to bring that to the court's attention. And I'd also like to just briefly say as well that to the extent that my friend's proposition is that economic considerations are relevant towards things like crafting a pandemic response, I'd just like to say I disagree with that. I mean, we cited the Edmondson case in our briefs that say naturally you would expect the governor to take the economy and protecting the economy into account when they make decisions. And that's also something that's reflected in this court's decision in the Moretti case, decided nearly 3 decades ago, where the state gives hundreds of millions of dollars in economic benefits to try to protect jobs in North Carolina and bring jobs to North Carolina. And I just want to avoid any suggestion that that's somehow inappropriate. So unless there are any further questions, we would respectfully request that this court reverse the Court of Appeals on the first claim. But as to the second and third claim I discussed, we'd ask for the court to be affirmed. Thank you very much.
Thank you, counsel. Thank you, everyone. Mr. Clerk.
All rise.